Good morning, everybody. The time is 10 a.m. This meeting of the Judiciary Committee will commence, and we are going to go into a brief recess to caucus. Thank you.
Hello, clerk. Are we still in caucus right now?
All right, good afternoon, everyone. We'd like to reconvene the Judiciary Committee for April 4th, 2024. Seeing no remarks from my co-chair, we will jump into our agenda. Let's start at the top for the time being. I'll entertain a motion to JFS Senate Bill number 1330. The JFS is LCO 6960. Motion from Senator Winfield, second from Senator Kissel. Senator Winfield on the bill?
Thank you, Mr. Chair. Just briefly, the bill before us provides that the receipt of a summons and complaint by the defendant or the defendant's agent, which includes the defendant's insurer obligated to defend that action, is sufficient means to constitute the commencement of an action. The judicial branch had language they wanted added, and that's the language in LCO 6960. Which in lines 16 and 17 adds the words "in the underlying action." Through you, Mr. Chair.
Further discussion on this bill? Further discussion? If not, maybe Representative Fishbein for motion, please.
Thank you, Mr. Chairman. Mr. Chairman, I move that we create a consent calendar and that we move number 1 SB 1330, an act concerning an accidental failure to file an action to said consent calendar.
Is there objection to placing the item on consent? Is there objection? Seeing none, that is so ordered. Number 2, Senate Bill number 1380. I'll entertain a motion for a JFS. It's LCO 1012, an act prohibiting discrimination by healthcare providers. Motion from Senator Winfield, second from Senator Kissel. Senator Winfield.
Yes, thank you again, Mr. Chair. The bill before us is intended to prohibit healthcare providers from discriminating against persons in the provision of the healthcare service they provide in this state. This is a bill that's been before us in prior sessions. There is JFS language from LCO 7012. This is language that was language being worked out in the Senate. The last time we had the bill, we take it as a friendly language, which is why it's in a JFS as part of the ongoing conversation around this. Through you, Mr. Chair.
Discussion, Senator Kissel.
Thank you very much, Chairman Staffstrom. I just want to thank Senator Winfield, our good co-chair, for accepting the substitute language. It actually addresses a concern that was raised by Senator Gordon, who in his other career path is a physician of high esteem, and appreciate the collegiality regarding the movement of this bill. Thank you, Mr. Chair.
Representative Fishbein.
Mr. Chairman, I make a motion that we move SB 1330, an act prohibiting discrimination by healthcare providers in the provision of healthcare services, to the consent calendar.
Objection placing this item on consent. Is there objection? Seeing none, that is so ordered. Number 3, Senate Bill number 1388, an act concerning failure to move over. The motion is a JF.
Second.
Motion from Senator Winfield, second from Senator Kissel. Senator Winfield.
Thank you, Mr. Chair. This bill provides that a violation of Section 14-283B of the statutes that results in the death of an operator or any occupant of an emergency vehicle constitutes the circumstances that would show an extreme indifference to human life and a criminal prosecution for manslaughter in the first degree. So, JF.
Is there discussion? Is Representative Trubisky?
Thank you, Mr. Chairman. I just note that the way the language is written, it may not cover a officer or somebody else standing next to a vehicle. It would only cover people in the vehicle. But you know, as it goes forward, people should consider that. Thank you.
Further discussion on the bill? Further discussion? If not, Representative Fishbein.
Sorry. Chairman, I make a motion that we move item 3, SB 1388, an act concerning failure to move over for an emergency vehicle resulting in the death of the operator or other occupant of the emergency vehicle, to the consent calendar.
Is there objection?
No if I may, Mr. Chair?
Representative O'Day, I see your hands up. Do you have an objection to place
No,
this on?
no objection. I just wanted to thank the committee. This is a very important piece of legislation to protect our responders and DOT workers, and I thank the committee. Thank you.
Okay. Further discussion, If not, then moving to consent is so ordered.
Yeah.
Okay, all right, moving on. Number 4, Senate Bill number 1437, an act concerning requests for health records. The motion is a JF.
Second.
Motion from Senator Winfield, second from Senator Kissel. I believe this bill establishes time and cost parameters related to requests for copies of health records. Representative Fishbein, to you first, please.
Thank you, Mr. Chairman. Mr. Chairman, one of the problems here is that providers are getting records, haven't had an opportunity to review those records, yet the payment is already received by the provider. Therefore, I think it's appropriate that the payment should happen after receipt and review, or at least an opportunity to review those records. And therefore, Mr. Chairman, I make a motion that, and I do not have actual language, I leave it to LCO to craft that language, that payment for the records would be due after receipt of those records. So moved.
Second.
All right, so it's been motioned by Representative Fishbein. It's been seconded by Senator Winfield. Elsie, I'm going to turn to you just to make sure you have sufficient clarity as to what the proposed amendment would do.
Yeah, yes. So I understand what Representative Fishbein just conveyed is that payment for the record is due after the receipt of the record. Where that gets integrated into this bill right now, I can't say that I can give you a definitive answer on that.
Okay. Let's let the committee stand at ease for one moment.
I have an idea.
Exactly.
All right, so LCO, unless you have any concern with this, well, I think the committee understands what the intent of the amendment is and can vote on that. And if the amendment is adopted, we will allow discretion to LCO to determine where to insert that language. Is that acceptable to you?
Yes, that works.
Okay. All right, is there further discussion on the proposed amendment? Is there further discussion? Representative Quinn.
Yeah, just to be clear, section 1 deals with workers' compensation, which there is no fee charge. So I'm fully supportive of the amendment. It just should probably go into section 2 somewhere.
Yes, to your question or to your point, Representative Quinn, that would be my understanding too, that this just affects, the amendment just affects section 2, but let me confirm that with Representative Fishbein.
I concur. Thank you.
Representative Day, who's online.
Thank you. In line 68 to 76, I think that's where we'll go. And I support this amendment, and I urge my colleagues to do so as well. Thank you.
Okay, so for those who may not hear that, we're looking at line 68 through sort of 76, somewhere in there is where the language would go, and I'm seeing a head nod from LCO. Senator Kissel on the amendment.
Thank you very much, Chairman Staffstrom. And it's my understanding, I don't have the huge amount of experience regarding this, but rather than this concept being out of whole cloth, that this would actually mirror what is the practice when one orders a transcript. Is that correct?
That is my understanding, yes. Generally, if you take a deposition, the court reporter gets paid after you receive the transcript from the court reporter.
Thank you, Mr. Chair.
Further questions or comments on the amendment? Further questions or comments? If not, maybe I'll try your minds. All in favor of the amendment, please signify by saying aye.
Aye.
All opposed, say nay. The amendment is adopted. Further on the bill as amended. Representative Fishbein for a motion, please.
Thank you, Mr. Chairman. I move that we move item item 4, SB 1437, an act concerning requests for health records and fees charged for access to such records to the consent calendar.
Is there objection to placing the item on consent? Is there objection? Seeing none, so ordered. Number 5, Senate Bill number 1438, an act prohibiting female genital mutilation. The motion is a JF. Motion from Senator Winfield, second from Senator Kissel.
Thank you, Mr. Chair. This bill establishes the crime of mutilation of female genital minors as a class D felony. 3, Mr. Chair.
Is there questions or comments? Senator Kissel.
Thank you very much, Chairman Staffstrom. I know that we've worked on similar legislation in years past. It wasn't successful at that time. I'm hoping that this is the year that it'll successfully get passed by both chambers and signed into law by Governor. And I want to thank the leadership of this committee for moving it forward this afternoon. Thank you.
Thank you. Further questions or comments? Representative Fishbein?
Yes, thank you, Mr. Chairman. Mr. Chairman, in between our meeting and me coming back to my caucus, it was my understanding that there may be some objection to this bill. My understanding was it was consentable. So I just want to give the members of my caucus the opportunity. I'm going to shortly move it for the consent calendar, and that is their notice. So I'm talking a little bit slower here, just to give them that
Representative,
notice.
let me go to Representative O'Day online.
Thank you.
first.
I have no objection to this going to the consent calendar. I just have a couple questions for the good chairs. The key to this, as I understand it, is line 5, where it's directed to anyone, any woman under the age of 18 years of age, correct?
Senator Winfield.
Thank you, Mr. Chair. I believe that the representative is correct.
And so if a woman or person under the age or over the age of 18 wanted to have whatever type of surgery, that this bill would not prohibit that, correct?
Through you, Mr. Chair, as written in the bill, this bill establishes that crime for persons, as you suggested, under the age of 18. So it does not criminalize that over the age of 18.
And good chair, my understanding is we want to make sure that minors aren't mutilated or given surgeries that they can't consent to, because under 18 you can't give consent. Is that fair? Correct?
Sorry, I didn't mean to step on you. Through you, Mr. Chair, that would be my understanding, yes.
And so we heard some testimony that from a pastor that Connecticut does not allow any type of genital mutilation or surgeries on minors as it stands now, whether it's for the female genital mutilation or a male genital mutilation under the age of 18 by any doctor. Is that correct?
Through you, Mr. Chair, I don't mean to be obtuse, but are you asking me, I know this is going to sound tough, but are you asking me, did we receive that testimony? Because that's how you framed the question.
Yeah, yes, we received that. Well, I guess my question is twofold. One, that's my recollection of the testimony. And 2, is that testimony accurate?
Through you, Mr. Chair, it is my recollection that we received that testimony, and through you, Mr. Chair, I had not done a search of all the statutes to confirm that, but certainly should we put this in place, that would be true.
Yes, thank you, Mr. Chair. So under line 7, it sets forth a surgical operation. In line 6, it reads, a surgical operation is not a violation of subsection A of this section if such operation is, 1, necessary to the health of the person on whom it is performed, and is performed by a physician licensed pursuant to Chapter 370. Now, that does not include, though, as I understand, health of a person. Am I correct? That doesn't include gender affirming care. Is that accurate?
Senator Kissel. Senator Winfield. I was looking at Senator Kissel, Senator Winfield.
Thank you, Mr. Chair. So I don't believe that the language in the lines you are referring to, which are lines 6 through 9, are intended to relate to the issue of gender affirming care. No.
Thank you.
Representative Day.
Thank you, Mr. Chair. And heading down, surgical operation on line of 14 is not A, necessary to the health of the person on whom it is performed. My question is, what is the intent of that limitation? In other words, for purposes of this subsection, a surgical operation is not necessary to the health of the person to whom it is performed. So I guess it would be related to line 7. This is to make sure we don't include necessary operations for the person's health. And so I'm just making
Representative O'Day, if you would allow me, I think I can clarify what they're trying to get at there.
Thank you. Sorry.
We work together. All right. So you pointed to line 14, but I think you have to read line 14 through to line 18, right? So what it's doing is establishing that surgical operation could not be established as necessary for the health of that person if certain things are true. And if the basis for the belief of those things is that that person is doing it because it's a matter of custom or ritual. So I think if you read that in whole, you get an understanding of what's being attempted there.
Okay, thank you very much, Mr. Chair, and thank you for helping me. The why I'm bringing this up is, some people have their boys circumcised, and from what I understand, the custom or ritual part of this in line 18, let me ask it this way. What is that directed towards? Through you, Mr. Chair.
Senator Winfield.
So I think, and I will say that I'm not the author of this language, but I think what it's attempting to do is not allow that if that is solely the reason why one would do this. So there are folks who have circumcision, but there are medical reasons for circumcision as well, right? So the custom issues there, and there are medical issues there.
Thank you, Mr. Chair. Sorry, Mr. Chair. Thank you so much. I support this going to consent. I just want to make it clear whether you're, I don't believe anyone under 18 should have any medical treatment that's going to affect them for the rest of their lives, that's not medically necessary for their physical health. And so I appreciate this legislation going forward. I think it can actually go further. I don't believe anyone under 18 should be forced to receive any type of mutilation under any guise. So thank you. I have no objections going to consent. I just wanted to make sure I understood where we were
Further
going. And
questions or
thank
comments?
you.
Questions or comments? If not, Representative Fishbein.
Mr. Chairman, I make a motion that we move item number 5, SB 1438, an act prohibiting female genital mutilation to consent calendar.
Is there objection to placing the item on consent? Is there objection? Seeing none, so ordered. Number 6, Senate Bill number 1501, an act concerning probate court operations. The motion is a JF. Motion from Senator Winfield, second from Senator Kissel. Is there discussion? Is there discussion? Senator Kissel.
Thank you very much, Chairman Staffstrom. It's my understanding that I believe in Section 7 regarding a study regarding conservatorships that there's some other things that should be brought under the ambit of the study group. It's my understanding that Senator Ciccarella and Representative Howard, as well as maybe others, are working on that language, and they will continue to work harmoniously to perfect that. And so with that, I'm just thankful to the leadership for moving this bill forward. Thank you.
Thank you, Senator. Comment or question from other members? Comment or question from other members? If not, Representative Fishbein.
Thank you, Mr. Chairman. Mr. Chairman, I make a motion to move item number 6, SB 1501, an act concerning probate court operations to the consent calendar.
Thank you, Representative Fishbein. Is there objection to the motion before us? Is there objection? If not, item number 6, SB number 1501, will be moved to the consent calendar.
Thank you. Next, number 7, Senate Bill number 1544, an act concerning pre-settlement legal funding. The motion is a JFS, LCO number 7014. Motion from Senator Winfield, second from Senator Kissel. Representative Fishbein.
Thank you, Mr. Chairman. Mr. Chairman, I'll make an oral motion to change the date of the report from the current January 15, 2026, back a week to January 8, 2026. So moved.
Motion from Representative Fishbein, second from Senator Winfield. Just for clarity, so the amendment is to change 15 to 8 in line 33. Is that correct, Representative Fishbein?
Yes, thank you, Mr. Chairman.
Okay. Discussion on the amendment, If not, let me try your minds. All in favor, please signify by saying aye.
Aye.
All opposed, say nay. The ayes have it. The amendment is adopted. Further on the bill is amended. Representative Fishbein.
Thank you, Mr. Chairman. Mr. Chairman, I make a motion to move item number 7, SB 1544, an act concerning pre-settlement legal funding and loans made in connection with the anticipated receipt of a wrongful incarceration award to the consent calendar.
Is there objection to placing this item on consent? Is there objection? Seeing none, so ordered. Number 8, House Bill number 6872, an act revising and consolidating the hate crime statutes. The motion will be a JFS, LCO 7035. Motion from Senator Winfield, second from Senator Kissel. This is a bill that comes to us from the Office of the Governor, which would, as the bill suggests, consolidate our current hate crime statutes, which are spread across the general statutes, into one section of the penal code in order to make it clearer and to provide better guidance to both law enforcement and prosecutors so that they can appropriately charge hate crimes in our state, which certainly we have seen a prevalence of and uptick nationally on. The LCO, the JFS language in front of us makes several changes to the bill based on the feedback we received at the public hearing, including removing from the definition of protected social categories, someone's status as a veteran or victim of domestic violence. It removes Section 14 of the bill, which remains existing law, but is out of this bill with respect to any changes to it. It eliminates some of the enhanced penalties in section 23, except for enhanced penalties for very serious crimes. And it addresses the stacking of prosecution issues that the Office of the Public Defender rightly pointed out in reviewing the bill. Is there discussion? Senator Kissel.
Thank you very much, Chairman Staffstrom. I just want to thank Governor Lamont and his team for moving forward with this, and actually Mr. Hanratty and others, and the governor's administration working tirelessly over the last several weeks to try to polish up the language. It's my understanding that there's still some areas that are a little gray that need to be finished working on, especially regarding sacred implements or things like that. What is actually covered and what would rise to the destruction or harm done to an item that would constitute a hate crime. But certainly when we first addressed this issue, I didn't know that all our hate crime laws were scattered throughout the statutes, and having them in one area easily accessible by states' attorneys and others that utilize the statute will help to make them far more workable. It also allows individuals to know where the bright lines are, and there should be bright lines for behavior. But certainly it underlines and underscores the fact that hate has no place in our state, and I'm happy to support this matter going forward. Thank you, Chairman Staffstrom.
Thank you, Senator Kissel, and I agree. I think the bill that is before us to be voted on now is certainly an improvement over the first version of the bill, but I do believe there are some additional tweaks that are probably needed to this as it moves forward, including the definition of religious object. And also, I think we need to take a hard look at how this bill impacts juvenile sentencing and charges against juveniles. We need to be careful that bullying isn't charged as a hate crime, and I think we just need to make that clear moving forward. Representative Khan first.
Thank you. So I know that we've done some work on the draft that's before us today. And I know that there will be continued conversation on some of this language. I am going to be a no today, just to kind of flag what's before us. Specifically, I'm concerned with some of the language on not like how we don't correctly define or specifically define religious objects and religious property, and so that's section 5. And then I know the good chair, you mentioned on juveniles, I would love to see us work towards something that would kind of specify what that means. And my concern is really just that acts of bullying in schools do not become constituted as hate crimes in the future. So just want to hope that we can continue to work on that. Thank you.
Thank you, Representative, and duly noted. Representative Howard.
Thank you, Mr. Chairman. I too appreciate the work that's gone into this since its first iteration. I will just renew or restate for the record what I noted at public hearing regarding the substitution of crimes when the enforcement takes place in our judiciary, because people who commit crimes motivated solely by their hate for somebody for who they are, I think are a specific group of criminals that pose more of a risk than some others. And there still exist in here some minimum sentences, and I'm not opposed to them. And also certain crimes, for example, in section 3, where if not for the hate component would be a misdemeanor. So I would just like to say for the record and recognizing our separation of powers that I hope that the judiciary branch and the state's attorney's office in considering these things doesn't go down a road, for example, like 53A 181K as amended here and say, well, as part of an agreement, we'll take the hate part out of it and make it a breach of peace, or maybe an assault 3, I guess probably a breach of peace, to avoid the felony conviction, because then that hate component doesn't show up on a criminal record that is necessary for future incidents. Again, I appreciate the intent here to let those who prosecute crimes and hear crimes understand what the people's position is. So I'll support the bill today, but I just wanted to say that for the record that still concerns me in a variety of things that we do, but certainly here. Thank you, Mr. Chairman.
Thank you. Further discussion on the bill? Further discussion? If not, Madam Administrator, please call the roll.
Roll call vote on House Bill 6872, JFS the floor with LCO 7035 Winfield,
Winfield, in the affirmative.
Staffstrom,
Yes.
Lexer, Gadkar Wilcox, Pacino,
Yes.
Kissel, Fishbein, Blumenthal,
Yes.
Brown, Cabrera, Callahan,
Yes.
Chicarella,
Yes.
DiCaprio,
Yes.
Delaney,
Delaney, yes.
Dillon, Doucette, Dubitsky, Elliott, Gaston, Gilchrist,
Gilchrist votes yes.
Godfrey, Howard,
Yes.
Jacobson,
Yes.
Johnson, Khan,
No.
Lamarck Muir,
Yes.
Lesser,
Yes.
Marr, Miller, O'Day,
O'Day, yes.
Osborne,
Osborne, yes.
Pavlock D'Amato, Perillo, Quinn,
Yes.
Brahman,
Senator votes yes.
Roberts,
Yes.
Vertigliano,
Yes.
Sims,
Sims in the affirmative.
Veach,
Yes.
Walker,
Yes.
All right, we will hold the votes open until 4 p.m. Number 9, House Bill number 6918, an act prohibiting first cousin marriage. Motion from Senator Winfield, second from Senator Kissel. The motion, it should have said the motion, sorry. It's JFS, LCO number 7030. So the motion is a JFS 7030. The bill does what the title suggests. It prohibits first cousin marriage. The S language makes clear that this only applies prospectively. It does not void any existing marriage there may be in the state of Connecticut between first cousins, but does prevent first cousin marriage on a prospective basis after the effective date, which is October 1, 2025. Representative Fishbein.
Mr. Chairman, I make a motion that we add in line 2 of the S language between the words may and marry, the word knowingly. So moved.
Motion from Senator Kissel, second from Senator Winfield. I think the intent of the amendment is to make clear that if you don't know who you're marrying, then you don't know. Comment on the amendment, Representative Howard?
Thank you, Mr. Chairman, and I just want to thank the ranking member for the amendment. I do think it's important. Sometimes folks are estranged from their siblings, and cousins don't know their cousins. And this is probably part of a bigger conversation in this context, but the advent of ancestry DNA. I'll briefly say I worked with somebody for several years, and suddenly one day she put her profile on Ancestry DNA. Turned out we were cousins, and we'd been working together for years and never knew that. Obviously, I didn't marry her, but I fortunately already married somebody else. But it turns out that our grandparents were in fact sisters and foster children that were separated. So it was actually interesting to find that out and kind of go through the history of their entire family and whatnot. So the point is, I can see how it could happen, and I appreciate the amendment. Thank you.
Further discussion on the amendment? Further discussion on the amendment? If not, let me try your minds. All those in favor, please signify by saying aye.
Aye.
All opposed say nay. The ayes have it. The amendment is adopted. All right. Further on the bill as amended. Further on the bill as amended. How about Representative Fishbein for motion?
Thank you, Mr. Chairman. Mr. Chairman, I make a motion that we move item number 9, HB 6918, an act prohibiting first cousin marriage to the consent calendar.
Any objection to placing the item on consent? Objection, seeing none, so ordered. Number 10, House Bill number 6968, an act concerning juror compensation. The motion is a JF.
Seconded.
Motion from Senator Kissel, second from Representative Blumenthal. The intent of this bill is frankly to make it clear that paying jurors $50 a day is simply unacceptable, and that we need to and should do better by our jurors. Is there discussion? Representative Fishbein.
Thank you, Mr. Chairman. The concern that I raised, supportive of the language and supportive of the concept, certainly we should make it easier to have more people available for jury service. The concern, though, is this childcare reimbursement situation appears to just be permitted for those that are unemployed. And we would have it extend to any persons. So once again, I would suggest that LCO be empowered to take that intent and to craft language along those lines, and I move accordingly.
All right, before I take a second, so just so I'm clear on the amendment, if I look at line 59 of the bill, I think what you're asking us to do is strike the words an unemployed or part-time employed and just have the sentence start a juror who serves. Is that correct?
That's correct. Looking at the language, that would appear to meet the needs.
Okay. So that's a motion from Representative Fishbein, a second from Senator Kissel. Is there discussion on the amendment? Senator Kissel, followed by Representative Howard.
Thank you very much, Chairman Staffstrom. I support the amendment because some folks, has been explained to me earlier today by my good friend and colleague Rep. Howard, is like, one parent may be watching the children during the day, another parent may have the night shift, and they would not be brought in under the language that we currently have. I'm hoping that maybe as this bill moves forward, it can be tailored maybe more narrowly to address those situations, because certainly we don't want anybody serving jury duty, which is one of the great pillars that hold up our democracy, to be penalized just because of the work hours that they happen to do to make ends meet. And I am concerned that if it remains too broad, it might have too much of a fiscal note, and it may not make it through the appropriations process. But at this point in time, I think everybody should be included, and then we can maybe work on narrowing it down the road. Thank you, Mr. Chairman.
Thank you. Representative Howard?
Yeah, Senator Kissel mostly said it, but thank you. I support the amendment for exactly as he said. It seems to me that as drafted, it was designed to say, with the thought process perhaps that full-time employed folks are already paying childcare during the day. But that certainly does not, that ignores individuals who work shift work, whether it's in emergency services, factories, a variety of different places, our hospitality industry. When my boys were growing up, Shane and I worked opposite shifts for that reason, so that we didn't have to pay childcare. I worked second shift, she worked days, and that was like that for years. So if I had to be summoned to jury duty during the day, it would be a cost to incur us. And I think hardworking folks like us who are doing everything we can, or were back then, still are, but to care for our boys now, they kind of care for themselves. But to be ignored and left out and almost discourage full-time employment like that, I think was perhaps an oversight. So I'm glad it was rectified today. Thank you, Mr. Chairman.
Further discussion on the amendment. Representative Osborne?
Thank you, Mr. Chair. And I share some of the concerns voiced by Senator Kissel. And while I'll be supporting this out of committee today, as somebody who works full-time in our state judicial branch, I'm very cognizant of the many fiscal needs and the pressing fiscal needs that we have at the judicial branch. I'm concerned about the breadth of the fiscal note that this will take on, especially with respect to the childcare section, because it's not just childcare, it's family care that's undefined. There's no age for that family care to be provided. So as I said, I will be supporting this out of committee today, but I hope that we can take a look at this language because if it comes down to choosing things that absolutely desperately need to happen at the judicial branch and this particular priority, I think we need to take a hard look at that. Thank you, Mr. Chair.
Thank you. Further questions or comments on the amendment? Further questions or comments on the amendment? If not, I will try your minds. All those in favor of the amendment, please signify by saying aye. Any opposed, nay? The ayes have it. The amendment is adopted. Further on the bill is amended. Further on the bill is amended. Representative Fishbein.
Mr. Chairman, I move that we move item number 10, HB 6968, an act concerning juror compensation to the consent calendar.
Any objection to placing the item on consent? Any objection? Seeing none, so ordered. Number 11, House Bill number 7064, an act concerning revisions to the Validating Act. I will entertain a motion for JFS LCO number 6971.
Second.
Motion from Senator Winfield, second from Senator Kissel. This bill simply removes reference to instruments recorded after January 1, 1997. The S language makes a change to line 90 to say evidences instead of statements. Questions or comments on this? Glad there's not. Representative Fishbein for an amendment.
Mr. Chairman, I make a motion to move item number for an amendment or?
No, sorry, not for a motion, not for an
Okay,
amendment.
no
Sorry.
problem. Mr. Chairman, I make a motion to move item number 11, HB 7064, an act concerning revisions to the Validating Act to the consent calendar.
Is there objection to placing the item on consent? Is there objection? Seeing none, so ordered. Number 12, House Bill number 7065, an act concerning the decriminalization of possession of small amounts of psilocybin. The motion is a JF. In a second. Motion from Senator Winfield, second from Representative Blumenthal. This is a bill we've had before this committee, I think at least 2 previous years, maybe 3 previous years. What it does is it lessens the penalty for possession of psilocybin. I want to emphasize, it does not legalize psilocybin. It certainly does not legalize driving under the influence of psilocybin. All it does is reduce the current penalty for possession of under half of an ounce of psilocybin from an A misdemeanor to an infraction. Subsequent offenses are charged with a higher penalty. Senator Kissel.
Thank you very much, Chairman Staffstrom. Psilocybin, to my knowledge, is more commonly understood as hallucinogenic mushrooms. We've had ample testimony that people that ingest psilocybin or hallucinogenic mushrooms, or maybe in some other form, need a trip, what they call a trip buddy, because you sort of lose contact with reality. I don't know the intricacies of what actually takes place. I know that when we went down this path recently with recreational marijuana, and I understand we're not legalizing driving under the influence of mushrooms, but apparently from when I grew up to now, marijuana has gotten much, much more potent. I don't know what the capacity of psilocybin is. I don't know if it's more potent now than it was back in the day. But I am concerned that every time we make a step in this direction, we basically take the societal restraints away to some degree. And that unfortunately leads some individuals to think that they can mix this with either small amounts of alcohol or marijuana, and then they do end up driving. And we don't have enough ways to monitor who's driving under the influence or not, even though this is currently against the law and will continue to be against the law. But I think that we're just putting ourselves up for more problems regarding public safety. And I really get concerned with the message that it sends to our young people, although I will lead with this. The more and more I talk to the younger generation, the kids in high school or just going into college, they tend to be much more down to earth and conservative than maybe in the 70s when I grew up. So I think there's a lot of hope out there, but I still don't like the public policy direction this is moving, and that's why I'll still be voting no this year. Thank you, Mr. Chair.
Further questions or comments on the bill? Representative Howard.
Thank you, Mr. Chairman. I just want to say that I concur with the good chair's representation and in fact, accurate statement that this is not legalizing psilocybin and it is not legalizing driving while under the influence of psilocybin. Nothing in this bill does that. But I would say that, and I don't remember exactly when, I think it was probably around 2013 or 2014 when the legislature decriminalized marijuana. And then certainly in 2021, we legalized marijuana. As we sit here today, as we heard from one of our chiefs about drug recognition experts in one of our final public hearings, I actually took some time after that to learn more about drug recognition experts because I'm not one. I'm not overly familiar with them. But I learned there's only about 60 in the entire state for 169 municipalities. They have a call-out network that seems to work somewhat, but there's only 60. And part of the reason for that is because there's some federal funding, at least for the moment, that reimburses training for DREs and DRE instructors, but there's no reimbursement for the backfilling of that overtime. So what does that mean? That means that a police department in the state of Connecticut, and all police departments, I would assume, all that I know of, have minimum staffing. That means there's a minimum number of people that have to be working on any given moment in time. So if that number is 10 and one of those individuals is sent out for training, somebody has to be paid overtime to fill that spot. And that money is not being reimbursed. And as I understand it, in speaking with some drug recognition expert trainers in the state of Connecticut, that's one of the barriers to getting more. I think today, while we are not, again, legalizing psilocybin, this, I would suggest, would be step one towards that. And I rely on the pattern that marijuana took in this legislature, where it was decriminalized, subsequently legalized. And as we sit here today, since 2021, there is no doubt that there has been an increase in fatal crashes on our roads. It's a statistical fact. There's a question as to why. Is it just because we legalized marijuana? Is it in part because we legalized marijuana? Obviously, there's some debate on that, but it is a fact that the fatal crash rate is higher. I will also say that as I drive around, and I drive probably as far as anybody back and forth to here, 63 miles, oftentimes I do smell marijuana coming from a vehicle on the road. Can't always tell you exactly which one. Certainly we'll discuss that at some point next week, I'm sure. But the point is, people are driving around smoking marijuana now because, I don't want to say they can, but they can smoke marijuana legally, right? So technically it's illegal to drive while doing it. But the point that I'm trying to drive at is, I do believe that there has been an increase in people driving under the influence of marijuana since we legalized it. If we're going, and I think that we sort of failed as a legislature, the state of Connecticut, by not having more DREs in place prior to doing the legalization that we did in 2021 for the public safety aspect of it. And so I would like to say today, if this is the route that we're going to get on again with another drug, and I will also say that the DREs that I spoke to told me definitively driving under psilocybin is a major, major public safety concern. And in fact, some proponents of psilocybin actually said that as well, that they totally do not think it's an appropriate drug to be on while you're driving. So to that end, Mr. Chairman, I would like to propose an amendment. It's only 5 lines. I do have copies to the clerk for just to being dispersed, but with your permission, it's 5 lines. I'm happy to read it.
Go ahead, Representative.
This would insert at the end of the bill a new section 10 to read as follows. Section 10, effective July 1st, 2025, the sum of $1 million is appropriated to the Department of Emergency Services and Public Protection for the fiscal year ending June 30th, 2026 to provide funding for the recruitment, training, and retention of drug recognition experts as defined in CGS 142227A in the state. So moved.
So motion from Representative Howard, second from Representative Fishbein. Let me say, well, I absolutely support the intent of this amendment, and I do completely agree that we need more drug recognition officers on our roads. And frankly, if I'm recalling correctly, one of the provisions of the cannabis legalization bill years ago was actually to appropriate a certain amount of the funding from the sale towards public safety initiatives, which would include training for drug recognition experts. I think before we make a general fund appropriation, which is what this bill calls for, and frankly is beyond the cognizance of this committee to do, I think we need to go back and look and track where that funding from the sale of cannabis is going and why more of that is not being used to train drug recognition experts. So, Representative, you certainly have my commitment to work with you on that issue moving forward, because I think we are certainly in agreement that we need more drug recognition experts. I would like to see that paid for out of the basically the tax revenue that's being generated off of cannabis sales as opposed to general fund. And like I said, my biggest issue with this amendment is we really don't have the authority to make this appropriations. There's another committee that does. So I'm going to ask my members to oppose this amendment today, because I think it goes beyond sort of our purview, but certainly happy to work on the issue moving forward. Further on the amendment, Representative Howard for the second time.
Mr. Chairman, I just want to thank you for your comments, and I would just like to say to the members, and I agree, we have an appropriations committee, but we just put a bill on consent that's going to have an appropriation, right? So I just want to remind folks, we do that on the regular, and I think one of our colleagues down the way raised the concern that particular fiscal note may be very high. So while I appreciate that this would require a transfer to another committee, I think it's appropriate to let the appropriations committee and the people know that if we're going to go down this road, that's what we're committed to. But thank you for your comments.
Further on this, do we need a roll call vote on this, Representative Howard? Okay.
Yes, please, Mr. Chairman.
Madam
Thank you.
Administrator, please call the roll.
Roll call vote on Amendment A on House Bill 7065. Winfield,
Winfield in the negative.
Dahlstrom,
No.
Lexer, Gadkar Wilcox, Fazino, Kissel, Fishbein, Blumenthal.
No.
Brown,
Rep. Brown's a no.
Cabrera, Callahan, Chicarella,
Yes.
DiCaprio,
Caprio's yes.
Delaney,
Delaney, no.
Dillon,
Dylan votes no.
Doucette, Dubitsky,
Yes.
Elliott, Gaston, Gilchrist,
Gilchrist votes no.
Godfrey, Howard,
Yes.
Jacobson,
No.
Johnson,
Johnson votes no.
Khan,
Khan votes no.
Lamarck Muir,
No.
Lesser, Mar, Miller, O'Day,
O'Day, yes.
Osborne, Pavlak Tomato,
Pavlak Tomato votes yes.
Perillo, Quinn, Brahman.
Yes.
Senator
Rahman votes no.
Thank you. And Representative Quinn?
Yes.
Thank you. Roberts,
Roberts is no.
Bertigliano,
Yes.
Sims,
Sims is a no.
Beach,
Beach is a yes.
Walker,
Walker, no.
Wilson,
Wilson is a no.
Senator Lesser?
Senator Lesser votes no.
Excuse me, Mar is a no.
Thank
And
you.
Gaston also is a no.
And Flexer is also a no.
Thank you. Final vote tally on the amendment, on Amendment A is 12 voting yea, 23 voting nay, and 5 absent.
The amendment fails. Further discussion on the bill? Further discussion on the bill? Representative Trubisky?
Thank you, Mr. Chairman. Mr. Chairman, we've been down this road before with marijuana. We had bills to decriminalize. We had bills to make it legal for medicinal purposes. We passed laws to create an entire industry for marijuana, and by many accounts, and in the opinion of many people, it isn't working out all that well. And we are seeing increased deaths on the road, and many legislators during the discussion of those bills, debate on those bills, anticipated that we would see exactly what we are seeing now on our roads. With regard to psilocybin, I've looked into this. Each time we've had one of these bills over the last few years, and it does appear that the substance in these mushrooms is has some medicinal uses. And if that is the case, it should be prescribed like a medicine by a doctor. Decriminalizing any amount, as we would be doing in this bill, doesn't do anything to help the people who would benefit from this substance. All it does is put us down the road to recreational use. And I frankly don't think it should be legal for recreational use, especially since we have never given the people of the state the opportunity to see if it is a worthy medicine. And I think that before we start heading down the road of legalizing it for recreational use, we should at least investigate and pursue going through medical professionals to give it to people who may really need it and don't just want it for fun. So, as I have done the last couple of times that this proposal has been up, I will be opposing this. Thank you.
Thank you. Further discussion on the bill? Further discussion? If not, Madam Administrator, please call the roll.
Roll call vote on House Bill 7065. JF to the floor. Winfield,
Winfield, in the affirmative.
Staffstrom, Flexer, Gadkar Wilcox, Pazino, Kissel, Fishbein, Blumenthal, Brown,
Rep. Brown votes yes.
Cabrera, Callahan,
No.
Chicarella,
No.
DiCaprio,
No.
Delaney,
Delaney in the affirmative.
Dillon,
Dylan votes yes.
Doucette,
Yes.
Dubitsky,
No.
Elliott,
Yes.
Gaston,
Senator Gaston votes yes.
Gilchrist,
Representative Gilchrist votes yes.
Godfrey, Howard,
No.
Jacobson,
Yes.
Johnson,
Representative Johnson votes yes.
Khan,
Khan votes yes.
Lamarck Muir,
Yes.
Lesser,
Senator Lesser votes yes.
Marr,
Senator Marr votes yes.
Miller, O'Day,
O'Day votes no.
thank you, Osborne, yes, Havelock Tomato,
Pavlik Tomato votes no.
Perillo, Quinn,
Yes.
Rahman,
Yes.
Roberts, Rutigliano,
No.
Sims,
Sims in the affirmative.
Veach,
Beach is a no.
Walker, and Wilson.
Walker, yes.
Thank you.
Wilson is a yes.
Thank you.
Roberts is a yes.
Thank you.
And as a reminder, votes are open till 4. Okay, Turning our attention to number 15 on our agenda, House Bill number 7134, an act concerning enhanced protections available under the state's anti-SLAPP statute. The motion is a JF. Motion from Senator Winfield, second from Senator Kissel. This bill provides an opportunity for an early hearing on a claim where someone who has been a victim of sexual harassment or sexual assault has a claim filed against them in an attempt to silence their speech, instead of having to wait for a summary judgment motion to present evidence of why they believe that claim does not pass muster. It can be dealt with at an earlier procedural stage by a judge on what's called a special motion to dismiss. Mirrors language we already have in place with respect to First Amendment free speech matters. Is there discussion on the bill? Is there discussion on the bill? If not, Madam Administrator, please call the roll.
Roll call vote on House Bill 7134 to JF to the floor. Winfield,
Winfield in the affirmative.
Staffstrom,
Yes.
Flexer, Gadkar Wilcox, Pazino,
Yes.
Kissel,
Yes.
Fishbein, Blumenthal, Brown, Cabrera, Callahan,
Yes.
Chicarella,
Yes.
DiCaprio,
Yes.
Delaney,
Delaney, yes.
Dillon, Doucette,
Yes.
Ubitsky,
No.
Elliott, Gaston,
Senator Gaston votes yes.
Gilchrist,
Representative Gilchrist votes yes.
Godfrey,
Yes.
Howard, Jacobson,
Yes.
Johnson,
Representative Johnson votes yes.
Khan,
Khan votes yes.
Lamarck Muir,
Yes.
Lesser,
Lesser, yes.
Mar, Miller, O'Day,
O'Day votes no.
Osborne,
Yes.
Pavlock D'Amato,
Pavlock D'Amato votes no.
Perillo, Quinn,
Yes.
Rahman,
Yes.
Roberts,
Roberts, yes.
Retigliano, Sims,
Sims in the affirmative.
Beach,
No.
Walker,
Walker, yes.
Wilson,
Wilson is yes.
Blumenthal,
Number 16, House Bill number 7135, an act concerning the provision of reproductive and gender affirming healthcare services. The motion is a JFS LCO 6981.
So moved.
Motion from Senator Kissel, second from Representative Blumenthal. My apologies. Motion by Senator Winfield, second by Representative Blumenthal. Sorry about that, Senator Kissel. This is a bill that expands upon the so-called SHIELD Act that the legislature passed in 2022. It extends protections provided to Connecticut providers when they're providing telemedicine services. The bill also extends many of the same SHIELD protections to the provision of fertility services, as well as to gender affirming care. Is there discussion on the bill? Representative Fishbein.
Thank you, Mr. Chairman. For any of you that were here for the public hearing, you'll know that there is plenty of opposition to this bill from both sides of the aisle. One of my concerns is the states' rights issue. Clearly in lines 30 and 31, we are saying that this is an attempt to shield providers, whether or not the patient was physically located in the state at the time the services were provided. So, certainly if another state doesn't allow certain services, but Connecticut does, we control that licensing. We control by statute and regulation what they can and what they can't do. Other states have those rights also. So within the confines of their states, and certainly if somebody wants to avail themselves of a right or a service that is offered in Connecticut, move to Connecticut. But that's not what we have before us. So in addition to the numerous opposition that came before us, I intend to vote against this bill. So thank you, Mr. Chairman.
Senator Kissel.
Thank you very much, Chairman Staffstrom. I'm going to be voting no to flag this bill as well. I understand the underlying need to be protective of the rights that we have established here in Connecticut. I get that, and I totally support that. It gets a little more complicated, though, as medicine and technology have sort of marched forward, and we're always, as a legislature, playing catch up. For example, one of the items here that was discussed in the public hearing was, like the morning after pill for abortions. And that can be prescribed here, but taken by a person, let's say in New York or Massachusetts, maybe even that healthcare institution or prescriber is located here. And so you start to get into this complicated area of, do you need a legal nexus here within the geographic boundaries of Connecticut? Are we actually offering a safe harbor for individuals that may not be able to get treatment in a state like Texas? And also with the whole gender affirmation, to me, it's less problematic as you move to 18 and above, where an adult can make their own life choices. But then how much does that touch minors? And do we get into that whole kind of very fast moving, complicated area? So there's a lot of moving pieces in this area of law and a lot of strong beliefs on both sides of these issues. And I sort of have to flag this at this point in time and then try to study it further as it moves down the path. Thank you, Mr. Chair.
Thank you. Further questions or comments? Representative Drabitsky.
Thank you, Mr. Chairman. I was going through this bill and I swear I could not for the life of me fathom how this could be put together in such a way. To say that reproductive healthcare services and gender affirming healthcare services have the same meanings is to ignore reality. It's to ignore facts. One is to provide actual health care with regard to reproduction. The other, in many instances, is used to mutilate little children. And it baffles me that intelligent people in this legislature would look at this and say that those two things are the same. They are not. We should not be equating the hacking off of body parts, perfectly healthy body parts of children that don't have the mental capacity to consent to being mutilated for life. How we can equate that with an adult couple who is trying to have a baby and needs medical care. I think it's barbaric, and I will not be any part of it. Thank you.
Further questions or comments on the bill? Representative O'Day.
Thank you, Mr. Chair. Just to confirm, I appreciated the summary. Hopefully my volume is better now than it was.
Yeah, Representative O'Day, that's why both the rules and this committee encourage in-person participation in committee meetings, but we can hear you much better now. Thank you, sir.
Yes, I apologize. Thank you. As I understand the good summary, this is for protecting as I heard the good chair describe it, telemedicine, Connecticut doctors or medical providers providing telemedicine. My question is, does this bill protect, say a child age 14 or 15 is taken to Connecticut to go through gender affirming care in Connecticut? Would that minor be able to have their breasts removed and then return to the state that may not allow them? Well, first of all, let me ask it this way, Mr. Chair. As I understand that there was some testimony that minors in Connecticut cannot have, for example, their breasts removed under our current law. Is that accurate?
That's not addressed by this bill, and I don't know the answer to that.
Okay. Well, does this bill protect a physician who removes the breasts of a minor who does not live in Connecticut and is not accompanied by a parent?
Representative, I believe the provision of the bill I was referring to in my opening was with respect to telemedicine. So it's a provider who provides telehealth services to someone when, although that provider may be physically located in Connecticut, they're providing services in another state in which they are also licensed. I believe that's the only extension that is provided under this bill.
Okay, so this bill, then if I understand it, I'm sorry, I read through it. It's limited to telehealth provisions?
No, but the provision you're referring to or questioning about my opening summary of the bill, I was referring to the telehealth provisions.
Okay. All right, so in reading this though, is a minor allowed to, an out-of-state minor allowed to come to Connecticut without their parent and have their breast removed? And would that doctor be protected under this law if it were enacted?
Representative, this bill does not in any way, shape, or form change what doctors in Connecticut are allowed or not allowed to do. All it does is shield them from liability by another state if they perform or provide medical services in Connecticut that are otherwise authorized under Connecticut law. It does not change what's authorized under Connecticut law or not authorized under Connecticut law.
So right now, if a doctor performs mastectomy on a minor, would that minor, say they've lived in Delaware, that didn't otherwise allow it without the parental consent, could that minor later sue the provider in Connecticut who performed that mastectomy without parental consent if this law passes?
Representative O'Day, again, I am not a medical doctor, nor am I an expert on public health laws, but this bill does not change what is legal or authorized procedures under Connecticut law or not. If someone is, if a doctor is lawfully allowed to perform a procedure in Connecticut, they can continue to do so. This bill does not change that. All this bill says is the person may not be sued in or by another state for doing so. Certainly, if there's a malpractice claim, that claim can be brought where the tort was committed, which would be here in the state of Connecticut through you or to you.
Thank you. This statute is providing immunity to healthcare providers, as I understand it, correct?
No, that's not correct.
So what does this bill do?
I believe I said that it provides a shield against lawsuits that would be brought in another state to someone who performs or provides medical advice in Connecticut where that medical procedure is allowed by Connecticut law and that individual is authorized to practice law here in the state of Connecticut. Provide medicine in the state of Connecticut.
So Thank you, Mr. Chair. And so as I read lines 14 through 19, this does include treatment for gender dysphoria. And then if you combine that with lines 129, or I'm sorry, 88 and 89, it says that written consent of the patient or the patient's conservator or guardian or other authorized legal representative shall not be required for disclosure. Let me ask this. I'm sorry, Mr. Chair, just lines 8, what are the purpose of lines 88 to 102? Where it adds or business associate.
Well, I think this is the medical records provision. I believe most of lines 88 through 102 are existing law. And this provision of existing law, I believe, provides protections for individuals so that their medical records are not disclosed to another state if a state actor asks to subpoena those. What this does is provide the protection that otherwise would be provided to the individual or to their records from being subpoenaed if they were at a hospital system, also to one of these third-party medical service providers that so many of our hospitals seem to have outsourced their medical records to.
I thank you, Mr. Chair. I agree that the outsourcing the medical records issue is a huge one, and I appreciate the earlier bill being brought up. My concern is, so what is the reason for adding or business associate in lines 92 and 94 of this section?
Because right now, if another state's attorney general tried to subpoena your medical records, Representative O'Day, or a family member's, and those records were being held at Yale New Haven Health specifically, or your individual doctor's office, they would be protected from disclosure. But if they subpoenaed the third-party medical provider, who is not your individual doctor, but are being housed by that third-party provider, this provides the same protection with respect to those third-party providers as currently exists under existing law for your individual doctor's records. To you.
Thank you, Mr. Chair.
Further questions on the bill? Further questions on the bill? Let's go to Representative Gilchrist.
Thank you, Mr. Chair. I just think it's important to clarify for the record that the morning after pill and abortion are two distinct types of reproductive health care. The morning after pill prevents pregnancy, whereas abortion ends pregnancy. Thank you, Mr. Chair.
Thank you. Representative Howard, first followed by Senator Chigarella.
Thank you, Mr. Chairman. I just wanted to focus on Section 8, and not for very long, only because we don't really change it, limited at best. But there's a criminal violation aspect to this. So the last of the S language, end of page 11, starting in page 12, around line 342. Am I to understand that what that section does, with this slightly modified definition now, is if an individual commits an act in another state that is illegal in that state around gender affirming care, and that, we'll just say it's, Alaska, for example, Alaska has an outstanding warrant and a grand jury indictment, and they want somebody from our state, we will refuse to cooperate with them under this law?
I don't know that I'd specifically put it in those types of terms. I believe the intent of this is, as we're seeing right now in New York State, where a New York doctor provided medical services that were legal under New York law, but is being essentially charged for that by another state, that yes, we would not extradite that person to another state for providing services that are legal under Connecticut law.
So, but as I read this language, it seems that, and I'm happy to be corrected because it is a bit confusing to me, but it seems that if somebody were to commit a violation of law in New York, say, that's a violation of law in New York, and they were in New York when they committed the violation, but they're currently in Connecticut, and that violation surrounded gender affirming care as we've redefined it, would we turn that person over to New York if this passes?
I don't believe that's changed in this bill.
Yeah.
I think the answer to that is
I'm in a meeting here.
Representative O'Day, could you mute? Sorry about that. Do you mind muting? Sorry, Representative Howard.
That's okay.
My understanding is that remains unchanged in this bill.
Well, I appreciate that the process remains unchanged, but we're sort of expanding, again, I acknowledge not by much, when that would apply, but I'll move on to the next section. The next section seems to do similar to what we do with our Trust Act, which prevents a public agency, which would include law enforcement agencies and many others as defined, for using time, money, facilities now for gender affirming care, as well as the existing language. So if I'm a police officer and somebody from another state calls and says, hey, we have an investigation going because gender affirming care is illegal in our state. Again, we'll use New York for an example. Say it's gender affirming healthcare services are illegal in the state of New York by their laws. And we need some information on this particular individual. If you have any address information where they work so we can contact them. It seems to me the police officer would be forbidden from sharing that information. Is that true?
That's my understanding.
All right. So, I appreciate the fact of what we're trying to do here. And I had this conversation with somebody not in this legislature recently. And, there are things that go on in other states and even in the federal government that frankly I don't agree with. And we do a good job here in Connecticut of creating laws for our state that are important. And I think even in these sensitive issues like this, for example, when we go down this road and say, well, we're not going to cooperate with other states because we don't agree with their laws effectively, it creates an issue. And I'll speak specifically to law enforcement. It is so important that law enforcement agencies be able to communicate, not just in the way that folks move around, but especially in this digital world. Every day in the state of Connecticut, people take complaints, officers take complaints of online harassment, online theft, et cetera, where we really rely on our brother and sister officers in other states. And, when we watch what goes on, in the whole world, nationally, and globally, like we're watching right now, with the tariffs, we add a tariff, the other country retaliates and says, okay, if you're going to do that, we're going to do this. And I don't want to go down that road with other states and to take this particular issue out, because it's not just about this issue. It's about the taking a holistic look at it and say to some of my colleagues on the other side of the aisle, imagine if somebody came here and sold a bunch of high capacity magazines and assault rifles. And I had that investigation and that individual is currently living in Texas. And I called Texas and say, hey, can you give me some information on this guy? And they said, no, blue state, Connecticut, your laws are ridiculous and we don't agree with them, so we don't cooperate with you. That'd be frustrating, right? Because now I can't enforce the laws that my legislature agreed on, that I've been charged with because of this sort of way that we're going about this. And, it's not that I don't support folks, and I do disagree wholeheartedly with any state that tries to prosecute individuals who committed an act that was in another state. So in other words, if somebody's committing an act here, it's not for any other state to prosecute that act. That's for us to do. To provide it's a violation of our laws. And if it's not, then they don't get prosecuted. But I think this goes about that in the wrong direction or in the wrong way. And I think it sets a potential problem in motion that is only going to grow and will have an adverse effect potentially in a lot of ways that we do enforcing of the laws that we agree on here. So unfortunately, I can't support it. Thank you, Mr. Chairman.
Further questions or comments on the bill? Further, Representative Blumenthal?
Thank you, Mr. Chair. And I just wanted to clarify a couple things very briefly and briefly respond to some of the arguments we heard and thank the committee chair for their work. This bill does not change the protections regarding gender affirming care. It merely recodifies existing law. And I want to thank the leadership of the committee for helping expand this legislation to cover all entities that have control of medical records so we can protect people's privacy and protect providers who provide telehealth. So thank you, Mr. Chair.
Further questions or comments? If not, Madam Administrator, please call the roll.
Roll call vote on House Bill 7135 with LCO, JFS to the floor with LCO 6981. Winfield,
Winfield, affirmative.
Staffstrom, Flexer, Gadkar Wilcox, Pazino,
Yes.
Kissel, Fishbein, Blumenthal,
Yes.
Brown,
Brown's a yes.
Cabrera, Callahan,
No.
Chicarella, DiCaprio,
DiCaprio, no.
Delaney,
Delaney, yes.
Dillon, Set,
Yes.
Dubitsky,
No.
Elliott, Gaston, Gilchrist,
Gilchrist votes yes.
Godfrey, Howard,
No.
Jacobson,
Yes.
Johnson, Khan, Lamarck Muir,
Yes.
Lesser,
Yes.
Marr,
Senator Marr votes yes.
Miller, O'Day,
O'Day votes no.
Osborne,
Yes.
Havelock D'Amato,
Pavlik D'Amato votes no.
Perillo, Quinn, Rahman, Roberts, Retigliano,
No.
Sims,
Sims, I'm sorry, Sims in affirmative.
Beach,
Beach votes no.
Walker,
Walker votes yes.
Wilson,
Wilson votes yes.
Moving on, number 17, House Bill number 7209, an act concerning legal proceedings involving housing matters. The motion is a JFS LCO 6999. Motion from Senator Winfield, seconded by Representative Fazzino. This bill does a few things. First, it permits the Attorney General to bring legal actions in response to allegedly discriminatory housing practices. It authorizes a court to assess attorney's fees against a losing party in an action brought under 830G. And it prohibits residential rental property owners from using pricing algorithms and competitive sensitive data to set rental prices. The JFS language removes the CUTPA violation from that last part of the bill and instead inserts a claim under the Connecticut Antitrust Act. Senator Kissel.
Thank you very much, Chairman Staffstrom. I support the initiative made by the proponents of this bill. I have problems with a couple parts of it. I always have a concern when we assess attorney's fees to the prevailing party. That's the English or British model. I prefer the American model where you are just responsible for your own attorney's fees. It can be really punitive when attorney's fees are assessed against the losing party. And the other part that I have a real problem with, while I understand the dilemma that we're coming up against in a variety of bills regarding artificial intelligence and our algorithms in the internet. And again, like I said previously, we do play catch up with technology. I have no idea how we go and figure out if a landlord's using a certain kind of software. And I don't want us to be like impeaching on or impeding on their privacy rights. Certain other areas of business may have computer programs. I have no idea what kind of algorithms they use. And I think it would be difficult figuring out what kind of program is embedded in a particular brand of software. I mean, if you watch television at night, you'll have like, things that protect you from hackers, things that help speed up your computer, all sorts of things. I have no idea what the programs are within there or what algorithms they may or may not use. So I just think that it's an area where it'd be very difficult to police. And I wonder whether it's even fair. I think we can look at the net result of what a landlord does or does not do. And if we have a policy interest in assessing whether that's heavy-handed or wrong, we can do that. But I don't want to sort of dig into how they get to that function. Because I just don't think that's the place for government. So for those reasons, I'm going to be voting no to flag it, but there may be parts of this bill I can support moving forward. Thank you, Mr. Chairman.
Further discussion or comment? Representative Doucette.
Thank you, Mr. Chair. I concur with some of what the good Senate ranking member said. I'm going to vote yes to get out of committee today. I appreciate the intent and the goals of this bill. I'm still a little confused by Section 3, although I do appreciate the change to take the cuppa out. So I'll vote yes to move it along, but would like to see some further clarification on that Section 3. Thank you, Mr.
Further
Chair.
questions or comments on the bill? Representative Dubitsky.
Thank you, Mr. Chairman. I align myself with the Senate ranking member with regard to Section 3. I think that it would not only be very difficult to enforce and to determine whether or not a given algorithm used the banned information, but our towns use algorithms. Every product and service these days uses algorithms of some sort. Your refrigerator has a computer that uses algorithms that figure out when to turn the motor on and when to turn it off. So I'm really worried about this really coming back and being a deterrent and preventing landlords from getting the information that they need to determine how to run their own businesses. Now, with regard to Section 2, I'm particularly worried that this is directed specifically at towns. So it does say that the applicant may be awarded attorney's fees, but the applicant is suing the town. So what this is doing is this is opening the door for awards of attorney's fees against zoning commissions in our towns for doing their jobs. And it does say that there needs to be either bad faith or cause to delay. Well, there may be legitimate reasons to cause to delay. So I'd be very hesitant to open our towns, especially our small towns, up to awards of attorney's fees. So, Mr. Chairman, I'm going to make a motion to strike sections 2 and 3 from this bill.
There's a motion to strike sections 2 and 3. The motion is made by Representative Drubitsky. It's seconded by Representative Fishbein. Let me respond on this on two parts. I'll go in the order the representative did. So on section 3, with respect to algorithm, I would remind folks that all this does is allow the investigation and a potential cause of action. The person bringing the action still needs to prove that one of these algorithmic devices was used, and that it relied on non-public competitor data, et cetera. So it is not in every instance the device is used. There needs to be a specific showing. With respect to section 2, I believe the good representative did start to say this does not allow for attorney's fees against a zoning commission in each and every instance. It only allows attorney's fees against a zoning commission in very specific circumstances. One, it needs to be the denial of an 830G application. It's not the denial of every zoning application, just those. And then in order to award attorney's fees, the court must find that the application was denied either in bad faith or to cause undue delay, which I don't believe there's ever legitimate reasons to deny an application to preserve undue delay. An application should get a up or down vote based on its merits. And what this says is that the commission can't just deny it in order to purposefully delay the developer's development of the property they own or control. The final thing I would raise on the attorney's fees point is this is not mandatory. Even if the court does find that the zoning commission acted in bad faith, the court can award attorney's fees. It is not required to, it's not a shall, it's specifically a may award attorney's fees in those very limited circumstances at the court's discretion and option. So with that, I would ask my colleagues to oppose the amendment today. Further on the amendment, if not, Madam Administrator, on the amendment, Representative Fishbein.
Thank you, Mr. Chairman. I'll be brief. With regard to section 3, my concern is that we're opening the door to a claim of a CUTPA violation. And, I wanted, should this ever become law, I think, and I do ask the chairman whether or not there needs to be an actual action that alleges a CUTPA violation, or under this language, are we authorizing the Attorney General to do a fishing expedition pre-litigation through you?
This does, could you rephrase the question, Representative Fishbein?
Sure. The concern is that we are describing this activity to be an unfair or deceptive trade practice. And, certainly the way our court process usually works is one has to allege and they have to prove. And I just want to inquire whether or not we are empowering the Attorney General to, contact every landlord in the state and, give us your documents as to how you ascertain rental levels pre-litigation. I just want to make sure we are not authorizing that here.
Right, I understand, and I think my confusion was actually, I think, Representative, you're looking at the underlying bill, which contained the unfair trade practice. Under the S language of the bill, which we're voting on, a violation of section 3 of the bill would actually constitute an antitrust violation. So it's specifically brought as, sort of where there's collusion, essentially, is what this is getting at, of where there are, say, multiple landlords and they're essentially fixing the price of rent in a particular geographic location. And so my understanding is this would, the underlying provisions of the Connecticut Antitrust Act as that law currently exists and on the books. Whatever tools are available under that act would be available here to you.
Specifically with regard, understanding that the CUTPA violation is removed in the S language. Under the antitrust, I'm not aware of any portion of the Antitrust Act that permits that sort of pre-litigation discovery. I just want to be clear that we are not authorizing that should this become law.
Assuming you're correct that pre-litigation discovery is not authorized under the Connecticut Antitrust Act, then no, pre-litigation discovery would not be available for these type of claims either.
Thank you for that answer.
Further questions or comments on the amendment? On the amendment, Representative Dubitsky on the amendment again?
Yes, Mr. Chairman, I just ask that when the tally be taken, it be taken by roll.
Duly noted. Representative O'Day, I see your hand up online. Is that on the amendment or on the underlying bill?
On the underlying bill. Thank you.
All right, Madam Administrator, please call the roll on the amendment.
Roll call vote on House Bill 7209, Amendment A. Winfield,
Winfield, in the negative.
Staffstrom,
No.
Flexer,
No.
Gadkar Wilcox, Pazino, Kissel, Fishbein, Blumenthal, Brown,
Representative Brown votes no.
Cabrera, Callahan,
Yes.
Chicarella,
Yes.
DiCaprio,
DiCaprio, yes.
Delaney,
Delaney votes no.
Dillon, Doucette,
No.
Dubitsky,
Yes.
Elliott,
No.
Gaston,
No.
Gilchrist,
Gilchrist votes no.
Godfrey, Howard,
Yes.
Jacobson,
No.
Johnson,
Sam Johnson votes no.
Khan, Lamarck Muir,
No.
Lesser,
Lester, no.
Mar,
Senator Mar votes no.
Miller, O'Day,
O'Day votes yes.
Osborne,
No.
Havelock Tomato,
Havelock Tomato votes yes.
Perillo, Quinn,
Yes. No. No.
Rahman,
No.
Roberts,
No.
Rutigliano, Sims,
Sam's in the negative.
Veach,
Veach votes yes.
Walker,
Walker votes no.
Wilson,
Wilson votes no.
the final tally is 10 voting yea, 25 nay, 0 abstaining, and 5 absent.
The amendment fails. Further on the bill, Representative O'Day.
Thank you very much, Mr. Chair. Just taking a look at section 2, lines 89 and 97. As I read it, plain reading, that doesn't allow, let's say the appeal of the commission's decision denying was made frivolously or without a basis or for bad faith. Can the commission get attorney's fees? I think I know the answer.
The answer is no.
So, and is there a reason why we're making this unilateral just for attorney's fees for one side and not the town?
So Representative O'Day, like I said, this is a very limited provision. We're not trying to change the rules with respect to more globally on when attorney's fees are or not awarded with respect to a zoning appeal. These are in the very limited instance where there is a 830G application that's filed and without good faith, the town denies that 830G application. You know, we've seen it where towns, you know, sort of have complained about that law and have said, well, you know what, let's just deny it. And if a court eventually overturns it, so be it. And this addresses just that limited circumstances and provides just the option that fees be awarded to the developer in that instance.
I mean, I would like to see that if an appeal is done in bad faith, let's say the commission denies it and has a valid reason, and a builder who's got unlimited resources, whereas a town does not, may be forced to, I mean, I believe a town should be able to get attorney's fees for a frivolous appeal by a builder. I assume, I mean, I don't want to waste time here. What I would like to do is see it reciprocal, that if there's a bad faith appeal of a decision denial, the court then could grant attorney's fees for the town.
So Dave, let me just say, I know it's Friday afternoon, folks are trying to get out of here. An amendment to make it reciprocal would not be a friendly amendment at this point, but I certainly would encourage you to have conversations with the proponent of the bill as the bill moves forward after today.
Okay. All right. Thank you, Mr. Chair.
Further discussions or comments on this? Further discussions or comments, Representative Osborne?
Thank you, Mr. Chair. And while I support many of the laudable goals of this bill, and I'm very interested in making sure that landlords aren't discriminatorily using algorithms to unfairly drive up the prices for renters, I too share the concerns I've heard about shifting the American rule for attorney's fees to favor developers in these instances. Some of my concerns surround the fact that, I practice in court every day. I know that judges are humans and they don't always get it right. They are the arbiters of credibility. It's a completely subjective standard whether a judge determines whether a party has acted in good faith or bad faith. And knowing the extraordinary fiscal burden this could place on municipalities and on taxpayers in communities that may not be acting in bad faith. I'm concerned about the chilling effect this could have on communities that are fighting developments that they don't feel are appropriate for their communities. And for that reason today, Your Honor, for that reason today, Mr. Chair, I will be a no vote on this, but I hope to be part of the conversation going
Further
forward.
questions or comments on the bill? Further questions or comments? If not, please call the roll, Madam Administrator.
Roll call vote on House Bill 7209, JFS to the floor with LCO 6999. Winfield,
One bill in the affirmative.
Statstrom,
Yes.
Flexer, Gadkar Wilcox.
Senator Gatto Wilcox is yes.
Thank you. Pizzino. Yes. Kissel. No. Fishbein. No. Blumenthal.
Yes.
Brown.
Representative Brown votes in the affirmative.
Cabrera. Callahan.
No.
Chicarella.
No.
DiCaprio.
Caprio's no.
Delaney.
Delaney votes yes.
Dillon. Doucette.
Yes.
Dubitsky.
No.
Elliott.
Elliot, yes.
Gaston.
Senator Gaston votes yes.
Gilchrist.
Gilchrist votes yes.
Godfrey.
Yes.
Howard.
No.
Jacobson.
Yes.
Johnson.
Johnson votes yes.
Khan.
Khan votes yes.
Lamar Muir.
Yes.
Lesser.
Lesser, yes.
Mar.
Mar votes yes.
Miller. O'Day.
O'Day votes no.
Osborne.
Osborne votes no.
Pavlik D'Amato.
Pavlik D'Amato votes no.
Perillo.
Perillo votes no.
Quinn.
Yes.
Rahman.
Yes.
Roberts. Retigliano. Sims.
Sims votes in the affirmative.
Beach.
No.
Walker. Wilson.
Walker in the affirmative.
Thank you.
Wilson is a yes.
Thank you.
Roberts is a yes.
Thank you.
Number 18, House Bill number 7250, an act implementing the recommendation of the Juvenile Justice Policy and Oversight Committee. The motion is a JFS LCO 7023.
Second.
Motion from Senator Winfield, second from Senator Kissel. Is there discussion on the bill? Representative Fishbein.
Thank you, Mr. Chairman. Mr. Chairman, in section 4, which deals with juvenile review boards and diversion programs, I believe is the language presently lies, that report would be made to DCF. And I think it would be more appropriate to expand who gets that report. Therefore, I make a motion to add to that list the state's attorney's office, as well as this committee being the chairs and ranking members of this committee. So moved.
All right, so we have a motion, we have an amendment from Representative Fishbein that's been seconded by Senator Winfield. I want to make sure LCO understands the motion. I'm looking at line 153 of the bill, and I think the amendment is to add the Office of the Chief State's Attorney and the Joint Standing Committee having cognizance over matters relating to the judiciary after the word families in line 153.
I concur.
Yes, I have that. Thank you.
All right.
But can I just ask, was it specifically to the ranking members and chairpersons of this committee, or was it to the committee in general?
Usually I'll leave it to the proponent of the amendment, but usually it's the language says just to the committee, and then it comes to the administrator who distributes to the leadership of the committee.
Yes, I have no problem with creating new language that we carry over and follow that practice. Thank you.
All right, so that everyone is clear on that, is there discussion on the amendment? Is there discussion? If not, let me try your minds. All in favor, please signify by saying aye.
Aye.
All opposed, no. Okay, the ayes have it. The amendment is adopted. Further discussion? If not, Representative Fishbein for a motion, please.
Mr. Chairman, I make a motion to move item number 18, HB 7250, an act implementing the recommendations of the Juvenile Justice Policy and Oversight Committee to the consent calendar.
Is there objection to placing the item on consent? Is there objection? Seeing none, the item as amended is placed on consent. Number 19 is House Bill number 7255, an act concerning judicial branch operations. The motion is a JFS LCO number 7021. Motion from Senator Winfield, second from Senator Kissel. This is our annual judicial branch court operations bill that comes to us from the branch. It has a number of sections relating to court operations and the operations of the branch. I will note in the S language, there's been significant changes to section 1 of the bill, which is one of the sections we heard quite a bit of concern about. That provision now makes clear that the onus is on the branch to identify sections of the public records that may need to be addressed. And I will represent as well that I know I think the language from the branch in section 1 is an improvement, but they are committed to continuing to work with stakeholders as this bill moves forward towards final action later in the session. Discussion on the bill, Representative Godfrey.
Thank you, Mr. Chairman. Since the public hearing on this Monday, I've been working on the section 1. I want to thank everyone who has made this much better. I want to give a particular shout out to Lee Ross from the Judicial Department, who has been working on this very carefully. There's 2 points I do want to make. The effective date is January 1st of 2026. There was a draft that said October 1st of this year. Town clerks are going to have enough to do in October with no excuse absentee balloting and early voting. I'm sure they are grateful that we pushed this off just a little bit. We made it perfectly clear that it's the covered person who has to initiate the process by which they can get certain records redacted. And in my discussions with the judicial branch, nothing in this will abridge any of the rights listed under the Freedom of Information Act, which I think is very important. We're doing the balancing act. We're protecting a class that needs to be protected, but we're doing it in a very sincere and a very practical way. So I encourage my colleagues to support this.
Thank you.
Mr. Chairman.
Further on the bill, Representative Pavlik D'Amato online.
Yes, thank you, Mr. Chair. And I want to thank everybody. And I know there was some discussion about some objection to some of the changes in the jurisdiction of various courts. And I do look forward to working with with certain members and individuals about making sure that we are utilizing our courts and that they are not overburdened with certain cases. So thank you, everybody.
Thank you. Further on the bill, Representative Osborne.
Thank you, Mr. Chair. And like Representative Pavlik D'Amato, I'm grateful for the engagement on sections 15 and 16 concerning venue of certain towns and municipalities. And I look forward to working on that in the future, and I'll vote yes at a committee. Thank you, Mr. Chair.
Further discussion? If not, Representative Fishbein for motion, please.
Mr. Chairman, I make a motion to move item number 19, HB 7255, an act concerning judicial branch operations and procedures and the duties of the judicial branch personnel to the consent calendar.
Seeing no objection, placing the item on consent, that is so ordered. And with that, Madam Administrator, I think we're ready for our consent calendar.
The consent calendar is consisting of Senate Bill 1330, JFS to the floor with LCO 6960, Senate Bill 1380, JFS to the floor with LCO 7012, Senate Bill 1388, JF to the floor, Senate Bill 1437, JFS to the floor with Amendment A, Senate Bill 1438, JF to the floor, Senate Bill 1501, JF to the floor, Senate Bill 1544, JFS to the floor with LCO 7014 and Amendment A, House Bill 6918, JFS to the floor with LCO 7030 and Amendment A, House Bill 6968, JFS to the floor with Amendment A, House Bill 7064, JFS to the floor with LCO 6971. And then House Bill 7250, JFS to the floor with LCO 7023 and Amendment A, and House Bill 7255, JFS to the floor with LCO 7021.
Sounds right to me. Seeing no comments on that, Madam Administrator, please call the roll on the
Roll
consent
call
calendar.
vote on the consent calendar. Winfield,
Winfield, an affirmative.
Staffstrom,
Yes.
Flexer, Gadkar Wilcox,
Senator Gadikar Wilcox is yes.
Pizzino,
Yes.
Kissel,
Yeah.
Fishbein, Blumenthal, Brown,
Rep. Brown votes in the affirmative.
Cabrera, Callahan,
Yes.
Chicarella,
Yes.
DiCaprio,
DiCaprio, yes.
Delaney,
Delaney votes yes.
Dillon, Doucette,
Yes.
Kubitsky,
Yes.
Elliott,
Elliot, yes.
Gaston, Gilchrist, Godfrey,
Yes.
Howard,
Yes.
Jacobson,
Yes.
Johnson,
Johnson is yes.
Khan, Lamarck Muir,
Yes.
Lesser, Mar,
Mar is yes.
Miller, O'Day,
Uday, yes.
Osborne,
Yes.
Pavlik D'Amato,
Pavlik D'Amato votes yes.
Perillo,
Perillo, yes.
Quinn,
Yes.
Rahman,
Yes.
Roberts,
Yes.
Rutigliano,
Yes.
Sims,
Sims in the affirmative.
Veach,
Veach is a yes.
Walker, Wilson.
Wilson is a yes.
Gilchrist is here, and Gilchrist is a yes. Sorry about that.
Thank you.
Lester is a yes.
Walker is a yes.
Okay. We're gonna, like I said, votes are gonna be open until 4 o'clock, so I'll let folks have time to get their votes in, both in person and online with the administrator. Just for scheduling purposes for next week, members, note that we will be meeting on Monday, Tuesday, not Wednesday because that's session day, Thursday, and potentially Friday as well. Plan for 10 a.m. starts each day with caucus and committee meetings to follow. So with that, we stand in recess and we'll see everyone at 10 a.m. on Monday. Have a nice weekend.
Senator Marr,
I think I missed three,
can
Kirsten.
you hear me?
Sorry,
Wait,
can you hear
yep, I
me?
can. Yeah.
Okay, I think I
Um,
missed three votes.
All right, so let's look for House Bill 6872 is my first one. That order. Okay, 6872. How would you like to vote?
Yes.
And then I need you for 7134.
Yes.
And I think that was consent. That's all I need. You're all set.
That's it. Okay.
Yep,
thank
that's
you
it. Thanks.
much.
Have a good weekend.
You too. Bye-bye.
Representative Johnson,
Afternoon, clerk. Thank you so much.
you got it. I need you for House Bill 6872. How would you like to vote?
Yes on 6872, please.
And then for 7135,
Yes on 7135, yes.
perfect. Thank you so much. You're all set.
And just to confirm, I voted yes, apologies, on the 7209.
You did vote.
Oh, good.
You
I
voted yes.
was
Yep.
worried I missed that vote entirely. Thank you.
No,
Have a
you're
great
good.
weekend.
You too. Take care.
Good.
Senator Gadkar Wilcox.
Hi there.
Okay, I need you for House Bill 6872. How would you like to vote?
Yes.
For 7065.
Yes.
For 7134.
Yes.
For 7135.
Yes.
And then, yes, that's all. You're all set.
Great. Thank you so much.
Thank you. Have a good weekend.
You too.
Senator Carrillo.
Hello.
How are you?
I have a bunch.
Yep. For House Bill 6872.
Yes.
For House Bill 7065.
Yes.
For 7134.
Yes.
For 7135.
Yes.
And then I got you for 7209, and then the consent calendar, I got you. You're all set.
Great.
Thank you. Senator Rahman,
Yes, I just want to see anything I'm missing.
you are missing one, I believe. 7135. How would you like to vote on that?
Yes.
Okay, and I have consent. Yeah, and then you're all set.
Thank you.
Thank you. Take care. Representative Roberts.
Yeah, I don't know if I missed any. I think
I have you listed as missing one.
Okay.
And it is for 7135. Let's see. I think we only have this. Yep. How would you like to
Yes.
vote on that?
An affirmative.
Okay, you're all set. Thank you so much. Representative DiCaprio.
Missing any?
I didn't have you listed as missing, but let me just double check what I have you. In case. Sure, this one. Nope, you're all set. Have a good weekend.
So, item number 13.
Item number 13, we skipped. We skipped 13 and 14.
We skipped through. Hmm. Okay, I got followed up there somewhere. All right, let me take a look at the list again.
Yeah, no worries. Let me
Thank you.
know. Yeah. Representative Delaney.
Yes, ma'am, Madam Administrator.
Okay, I think I have you as all set, but let me just confirm for you that you're there. Um, you are all set. You got everything. Have a good weekend.
Yes, ma'am, you too, and thank you for keeping us all squared away.
Of course.
All right.
Representative Elliott.
Hello.
I need you for 6872. How would you like to vote?
Yes. Oh, you got it? Okay.
For 7134,
Yes.
for 7135,
Yes.
and that's it. You're all set. Have a good weekend.
You.
Representative Godfrey, let's see. Godfrey's all set. Representative Pavlock Tomato, I definitely need you.
I think number 8.
Yes, that's exactly what I have. Yeah, how would you like to vote?
No.
Okay, and then I'm just gonna make sure. That's all I had.
Yeah, me too.
All right, cool. Thank you so much. Have a good weekend.
You too.
Senator Lesser.
Yes, hi. I think I didn't miss any votes, but if you don't mind checking, I would.
Yeah, for sure. I think you're good too. Yeah, you're all set. Have a good weekend.
Thank you, you too.
Representative Wilson.
Yes, I think I missed one.
I have you for 6872. How would you like to vote? For 6872?
Yes.
Okay, sorry. I didn't hear you. And then I think that should be everything, but I'll just confirm. And consent. Yeah, you're all set. Have a good weekend. Did you have any questions, Representative DiCaprio?
The skipped ones, I think I wrote, maybe I wrote for the wrong thing down.
Did you want me to go through your votes for them?
Do
Or
you
through the
mind,
agenda at least?
mind going through the list?
No, of course. All right, so on the agenda, so number 1 was consent.
Yep.
Number 2 was consent. 3 was consent. 4 was consent. 5 was consent. 6 was consent. 7 was consent.
Hold
We took a
on.
we took a roll call on 8. And I've got you for that. You voted yes for that.
Okay.
9 was consent. 10 was consent. 11 was consent. 12 was roll call, and I have you as voting no for that.
Okay.
13 and 14 we skipped.
Okay, so this is, okay, so this one was skipped. 13 and 14.
Yep, and then 15 was roll call, and I have
And-
you as voting yes.
All right, so that should be you have me for a yes on that one.
Yes.
I'm gonna be a no on that one.
Okay, okay. All right, so I'm gonna change it to a no for 7134, and then 16 was a roll call. I have you as a no for that.
Okay.
And then for 17, 17 was a roll call as well, and I've got you for a no for that. And then the last 2 were for consent, and I have you as a yes for the consent calendar.
Yes. Okay.
Okay.
All right. Thank you very much.
Yeah,
I
of
got
course.
when they skipped, I got mixed up. So
I totally can relate to that. Have a
you
good
have a
weekend.
nice weekend. Thank you.
I'm sorry, I was muted that whole time. Can you hear me okay?
Yes, I can hear you.
5 years of Zoom and it still happens, you know? Okay.
Yeah.
So I need you for 6872. How would you like to vote?
Okay, 6872. Hold on, there's one I had.
Number 8. That was the governor's bill.
Okay, yep.
All right, here's a yes. And then the other one I needed you for was 7135.
Oh, are you talking about 6872?
6872, yes.
Okay, I don't know if I need to abstain from that one. Is that the bill that's dealing with the Muslim criminalization of Muslims or something?
It like consolidated the hate crime statutes. So Representative, yeah.
Yeah. I think that one needs a little bit more work
Okay.
on it. So can I abstain from that?
You can, absolutely. I'll mark
Okay,
you as
yeah.
abstaining. Yep. 7065, I had you. I've got you for this one, and it was 7135. How would you like to vote?
Yes.
Okay, and then on the consent calendar.
Yes.
Okay, you're all set then. Have a great weekend.
Thank you. You too. Take
Okay.
care. Bye-bye.
Hi,
Hi, Senator. How are you?
I'm well. How are you?
Good.
Just
All
logging in to
right.
get some votes.
Okie dokie. So I need you for House Bill 6872.
Which one is that one? Can you
It's the
describe
governor's bill.
Oh, yeah, Senator Cabrera votes yes.
Okay. For 7065, which is psilocybin.
No.
Okay. For 7134,
Which one is that?
that's the anti-SLAPP statute.
Senator Cabrera votes yes.
Okay. 7135, which is reproductive and gender affirming healthcare services to patients.
Senator Cabrera votes yes.
For 7209.
Which one was that one?
Enacting legal proceedings involving housing matters and impermissible use of pricing algorithms in the sensitive data.
Senator Cabrera votes yes.
Okay. And then it should be the last one, just the consent calendar.
Yep, yes.
Awesome. You're all set. Thank you so much.
Thanks. Have a great
Have a
weekend.
good weekend.
Bye.
Hey, Senator.
I'm here. Give me a second.
Yeah, no worries.
I'm here.
Okay, so
How
I'm gonna
are
go
you?
through how are you?
All
All
right.
right, so I'm gonna go through, no worries. For the agenda, we went through items 1 through 7. We're on consent. Number 8 was the governor's hate crimes bill 6872. How would you like to vote on that?
Yes.
Okay. 9, 10, 11 were consent. 12 was 7065, the psilocybin bill. How would you like to vote?
I'll vote yes on that.
Okay. 13 and 14 we skipped. 15 was 7134, the anti-enhanced protections under the state's anti-SLAPP statute. How would you like to vote? Did I
Person,
lose you? Oh, there you go. Yep, there you
I
are.
lost you. Okay. So 13 and 14, you skip. 15,
Yep. 15, 7134. How would you like to vote? That was roll call.
yes.
7135, the next one was roll call as well. How would you like to vote?
That was roll call, yes.
The 17 was roll as well. 7209. How would you like to vote?
Yes.
And then the last 2 were on consent. So how would you like to vote for the consent calendar?
Consent is yes.
Okay, you're all set. Thank you so
Thank you.
much.
Have a nice
You
weekend.
too. Enjoy.
Bye-bye.
Hey, Representative, sorry about that.
That's okay.
All right, so real quick, what I needed from you was the consent calendar.
Okay, yes, on the consent calendar.
One of those. And then March 6, 8, 7, 2, I have you already. And then 7065, I have you. 7134, and then 7135, I need you.
7135.
Which is, it was the provision of reproductive and gender affirming healthcare services
yes.
to patients. Yes to that, and then 7209, I've got you. All right, that was it. It was that in consent, so you're good to go.
Thank you.
Have a good weekend.
You too. Bye.
Hi, Representative. How are you?
Good. How are you?
Good. All right, let me just move stuff around. Got myself confused. Okay. So let's see, 6872. So the first 1 through 7 were on consent. Number 8 was the governor's hate crimes bill. How would you like to vote for that?
Yes.
Okay. I got you for that one. For 7134, how would you like to vote?
Which one's that?
It is enhanced protections under the state's anti-SLAPP statute.
Oh, yes.
For 7135, you voted. 7209. I got you. And let me check the consent calendar. Got you. All right, you're all set.
Nice. Thank you.
Have a good
weekend.
Whenever you're ready, Senator.
I'm ready.
All right, so items 1 through 7 were on consent. Item number 8, which is the governor's hate crime bill, 6872. How would you like to vote on that? Yes, how would you like to vote on that?
Yes.
Okay. 9, 10, 11 were on consent. 12, how would you like to vote with 7065?
Yes.
And that one's psilocybin. Okay. Let's see. We skipped the next 2. 15 was roll 7134. How would you like to vote on that?
Yes.
7135 is the next. How would you like to vote on that?
Yes.
7209. How would you like to vote on that?
Was 7135, was that a JF or a JFS?
7135 was a JFS with an
Okay.
with S.
Okay.
It wasn't an amendment. It was a sub.
Yep. Sorry, go ahead.
Oh, you're good. 7209 is the next one.
Yes.
And then we have the consent calendar.
Okay, I'm a yes.
All right, you're good to go.
Thank you.
Have a good weekend.
You too. Bye-bye.